I thank you very much for this opportunity of presenting my thoughts on the subject of dispute resolution, dispute avoidance, and so on. Before I begin, I would like to explain what I'm about to do, in the sense that there may well be members in the audience who have experienced arbitration. There might even be a couple of attorneys, I don't know. But my remarks, as requested by the President, were intended to be for general consumption, for those, in other words, who were, who are not familiar with the exact process of arbitration and the other forms of alternate dispute resolution, particularly as it affects us in the building industry. So for those who have heard all this before, please bear with me. And for those who haven't heard it before, I hope you will find it of some interest. We've heard from previous speakers a number of interesting things on important subjects concerning the construction industry. What I hope to do, as I said just now, is to look at how we deal with the settling of disputes in the industry, which, as I mentioned just now, is commonly referred to as ADR, alternate dispute resolution. Alternate to what, you may well ask? In this case, it is the alternate to the court system. It's alternate to the going to court, and again, we'll come to that later. All of us, I'm sure, here today will recognize the problems of our antiquated and ill-served traditional Jamaican court system. I don't think there's any need for me to explain, even to the most naive of us here today, how badly the general public and the commercial public, in general terms, is badly served by the court system. And it's not up to me here today to go into the deficiencies of the system, except to say that it prevents the progress of natural justice. And that is exactly what we're trying to do when we talk about ADR. And after I've had a chance to review this whole question of ADR, and if time allows me, I'll try and give you an overview on some other forms of conflict administration, because arbitration is not the be-all and end-all of it, as you probably know. And later, after that, to offer some personal views on global issues that affect us in Jamaica. We're getting down to ADR in general before being specific. Let me say that it's not only used in connection with arbitration, although that system is probably the most widely used of the alternates. But it also encompasses other forms of settling disputes, such as mediation, conciliation, expert determination, mini-trials, and more recently, the process which I'm very much in favor of, called adjudication. And so with your consent, Mr. President and members, I will deal first of all with arbitration. The first point I would wish to make, ladies and gentlemen, is that the process of arbitration is not, and nor should it be, a copy of court procedure. Although certain rules of evidence and arriving at decisions must conform to the current laws on the subject, as well as the rules of, as I mentioned just now, natural justice. For those not acquainted with arbitration, let me say that the process need not be complex or unduly formal. If the agreement from which the dispute emerges or comes from calls for a sole arbitrator, which is usually the case, by the way, it then becomes the duty of the arbitrator to conduct and rule the process as he or she sees fit. Somebody once gave me a definition of arbitration. I forget who it was, so I can't acknowledge it. But in very simple terms, the definition is the appointment of an individual arbitrator or a tribunal to hear and decide between parties to a dispute arising from an agreement or a contract made between them and who agree that the decision of the arbitrator will be final and binding on them. So that, in a nutshell, is what the thing is all about. Next, who, you may well ask, can be an arbitrator? Well, in fact, anyone, as long as both parties agree to his or her appointment and agree that they will abide by their decision and that it will be final and binding according to the current law. Now, obviously, there's a lot more to it than just that. Obviously, to appoint an arbitrator, one needs to know if they know anything about the issue, the complications, or the whatever the details are of the initial dispute. It has to be somebody who understands the law, not knows it specifically and particularly, but certainly in general terms. And since I've just used the phrase according to the law, and in any case, since this term is applicable to all of our commercial and other activities, we have a problem here. And let me explain, before I go too far deeply into the subject, let me explain what the problem is. The current governing Jamaican law is an adaptation of a long since out-of-date colonial English law called the Arbitration Act of 1900. I'm going to say that again, 1900. It is regrettable. It is regrettable that none of our legislators, unlike most of our other English-speaking countries in this region, have seen fit to do away. Notice, ladies and gentlemen, I use the term do away because I believe it is so antiquated and irrelevant that no amount of tinkering or amendment can bring it back to life again. It has to be done away with this irrelevant law, and to produce one relevant to us in Jamaica in the 21st century. And Mr. President, if you'll indulge me, as well as all of us involved in one way or another in the construction industry, to issue a plea, not just on behalf of the building industry, but for all in Jamaica concerned with commercial activities. And this plea is to the Minister of Justice to expedite the promulgation of a long-awaited new Arbitration Act for Jamaica. I say that with great sincerity, ladies and gentlemen, and I hope that I will live long enough to see it. Well, having got that commercial out of the way, let me return to the main topic and tell you very briefly what's the big deal, what's the advantages of arbitration over that of litigation or the court system. There are many advantages, but let me just point out a few of them for those that are unfamiliar with the process. First of all, the process is less formal than the courts. Secondly, it is private. That means that if a dispute exists between two entities, two companies that wish to continue their commercial relationship, they don't wish to have a serious last man standing kind of fight, it can be done in private. Press is not invited, spectators are not usually invited, and the arbitration process, the hearing, is usually conducted within closed doors. Next, the award of the arbitrator is final and binding on the parties, and appeals are only granted in exceptional cases. We heard this morning a very cute side reference by one of our speakers. Who was it? Yes, Mr. Donald Moore made us a very slight reference to the Privy Council or the House of Lords, but that is very rare and doesn't happen every day of the week. Another advantage of arbitration is that the time and the place of the hearing is usually arranged to suit the parties. In other words, no courthouse is necessary. I've conducted arbitrations for construction disputes very simply, over and done with in possibly 7-10 days, without any elaborate hearings in somebody's conference room or possibly on the site, and so on. I'm not saying that all procedures are similar, far from it, but it can happen, and it sometimes does happen, that they are very simply organized and simply settled. The issues in disputes. This is another one of the advantages of arbitration, where if you go to court, for example, and you have a technical issue to be resolved, a technical dispute, which is based on an issue, I should have said, then a lay judge, unless he's a qualified engineer or perhaps an intelligent architect, I say that with reservations, of course, the judge will have to rely on other people, mainly called expert witnesses, to give testimony. And from my experience, I'm sure in some of the people here in the room today, expert witnesses vary considerably as to their attitudes and their environment and so on and so forth. So as far as I'm concerned, as a technical construction arbitrator, is the fact that I can tell, because I've been in the business a few years, been around the block a few times, as they say, and I can tell if somebody is truthful or not. Finally, it is claimed that arbitration is quicker than litigation. This is not always the case, unfortunately, but it's supposed to be. Okay, so those are the main advantages. But as an arbitrator, I really ought to be fair and point out that there are some disadvantages. As far as I can see, there are only two. One is that if you go to court, the cost of the judge is free. He doesn't charge for that. It's at the taxpayer's expense. And similarly, the use of the courthouse is also free. So those are the two exceptions to the rule. Okay, once the identity of the arbitrator, this is moving right along now. Once the identity of the arbitrator has been agreed, he or she takes over the entire proceedings. Then, after becoming familiar with the generality of the case, you'll usually call a preliminary meeting. This may be attended by any of the technical advisors as well as attorneys of the parties, if any. And the main purpose of this meeting, which in my experience, by the way, I must tell you, I find very, very valuable to sort out details in a preliminary meeting rather than later. But the main purpose of the meeting is to set out what I call the rules of the game. Unless the parties themselves have other rules they wish to use. And there are standard rules of arbitration that have been laid down by, as was mentioned earlier, FIDIC and RIBA, the International Chamber of Commerce, and so on. There are many organizations that deal with the settlement of commercial disputes that have their own rules of procedure. Basically, there isn't a great deal of difference between them all, but they all have like I say, the wording is different, but basically they're more or less all the same, and they set out as one would not begin a game of cricket without knowing the rules of the game thoroughly and properly, so that the umpire can perform his function. So an arbitration cannot be begun properly unless the rules are not only known to the arbitrator, but also understood by the parties. It's also very important. Now, what kind of rules are we talking about? What procedure rules are going to be used for the conduct of the arbitration? Well, so I won't go through all the list because it's quite extensive, but let me just bring you the highlights. First one is, and a lot of these, of course, may sound very basic and elementary, but they are obviously I think they're very important enough for me to bring to your attention today. And the first thing is, what is the dispute about? That may sound very simple, but sometimes two people can get into a quarrel, which results in a dispute, and the cause of the dispute could be lost because of emotion, whatever. So it's very important to find out, first of all, what is the dispute about? What are the salient particular issues? What is the genesis of the arbitration? Where does it come from? How does the arbitration get its birth certificate, if you like? And the answer is from the contract itself that the parties have entered into, from which the dispute originates. There are other cases, there are other methods of originating arbitrations, one of which, of course, can be an arbitration ordered by the court, because they have the power to do that. If they find something is too complicated, too technical, no points of law are involved, they'll say, go to arbitration, let the experts settle it, then come back for judgment. So that is another way it works. Another question I always ask is, do the part, in case of construction arbitrations, that is a site visit necessary? Again, may seem very obvious, but it's a question that has to be asked. If the parties want the arbitrator to see the problem in the flesh, as it were, then it is their prerogative for the arbitrator to do so. One thing he's got to remember, he or she has got to remember though, he can't go and look at evidence, as it would be called, or the site of a dispute with one party without the other one being present. If he does, then he's guilty of a thing called misconduct, which I may come to later, but it's not what you think. Then, how is the arbitration to be conducted? Is it going to be word of mouth? Is it going to be written pleadings? What are the methods of communication? And a number of other points which are very important for both parties to agree on. And all of this is, of course, as I said before, the arbitrator is in charge. He's the captain of this little arbitration ship, and he sets the rules, but he has to do so with the consent of both parties. The essential thing being a whole core and ethos of arbitration is that it is consensual. In other words, both parties must consent to what the arbitrator is doing, and conversely, the arbitrator must not do things that are not in his terms of reference or that he's not empowered to do by the law, empowered by the law so to do, rather. Now, depending on the size and complexity of the dispute, the list I've just given you, or the few items on the list, it may be longer or shorter. The main thing is for the arbitrator, who, as I just mentioned, sets the agenda for the preliminary meeting, is to try and get all these matters of procedure, including time scheduling, agreed up front, so that the process thereafter can continue without interruptions, such as kind of what shall we do next kind of thing, or I disagree with the date you suggested, and so on and so forth. But having done all that, having got the preliminary meeting out of the way, there are certain other processes that to a small extent imitate the court procedure. They're called interlocutory procedures. And these include the submission of claims, production of evidence where it's necessary, the acceptance of the claim and the production of a counterclaim or defense. And this goes on for a little bit, and there are other procedural details which I could go into detail, but it would detract from the generality of what I'm trying to say today. So please excuse me for that. And finally, on that particular subject, it's the arbitrator's job always to see that these processes do not get out of hand and produce delays in the process. Because sometimes if you have lawyers involved, they may use court tactics, for example, to influence or affect the actions and sometimes the judgment of an arbitrator. Well, arbitrators have to resist that sort of temptation and always be aware of the role I just described of being in charge of the proceedings. Well, changing the subject slightly, what we have found is that basically most cases boil down to how much or what is being claimed, the details of them, and reasons why the other side should pay. The other side, usually called the respondent in arbitrations, as opposed to the defendant in law, will demonstrate why they should not be responsible for such payment or action, and sometimes give details of a counterclaim as well. Oh yeah, a little point I'd like to make here for the more sophisticated of those interested in arbitration is that I really ought to point out that everything I'm saying this afternoon applies to what we call domestic arbitrations, that is, arbitrations that take place in Jamaica according to Jamaican law. There are other forms of arbitrations called international arbitrations, where the rules of procedure and the agreed law may well be different to our local standards. And international may be described as issues between parties which have their places of business in different countries. For example, a foreign bauxite company and the government of Jamaica, because their places of business are in two different countries, it would be considered an international arbitration and subject to slightly more different rules than domestic arbitrations. Okay, so now we're rolling on quite happily with our arbitration. The hearing itself will take place, and according to the agreement of the parties expressed in the record of the preliminary meeting, everything will proceed accordingly. The hearing, of course, is where, for those who are not acquainted with that particular expression. By the way, somebody asked me the other day, is if a deaf man attends court, is that called a hearing? So I beg your pardon, I digress. Sorry about that. Also, the arbitrator will have satisfied himself as to the correctness of all matters prior to the hearing. He or she will then outline in general terms how the hearing is to be conducted, matters dealing with evidence, witnesses, record keeping, most importantly, when refreshments will be served. But the arbitrator, joking apart, must at all times keep a firm hold on the proceedings, as I said just now, and to the best of his ability see that equality prevails in terms of whatever takes place, and that the time schedules are obeyed. All right, moving right along, as they say. After presentation of all the evidence by both sides has been completed, they will each deliver their closing addresses, very much like in the courthouse. That could be oral or written, depending on what they agree on. This will be a summation of the main arguments for and against the other side, and a restatement of why their case should succeed and the opponents should fail, and how they believe the arbitrator should deal with costs in the award. The arbitrator will then ask if there are any other matters left undealt with. He'll thank everybody present and then close the hearing. His or her, to be gender correct, his or her final act will be, after reviewing and considering all the evidence and arguments put forward by both sides, make a decision based on their assessment of all aspects of the process and make an award. That will be in precise and specific terms, which, and this is a very important point, terms of which must be capable of immediate enforcement. On that note, an arbitration award can be enforced in the same way as a judgment debt of the Supreme Court. And finally, although not required by the present law, I'm hoping it will be in the new law, if ever we get it, the arbitrator is advised to conclude the terms of the award by giving reasons for making their decisions. Very important, so that when the award is handed down, obviously somebody's got to win, somebody's got to lose, and so on. But it's important for everyone to understand how the arbitrator arrived at his decision. Was it correct? Was it based on the facts as presented to him? Does it conform to the current legislation? So on and so forth. So that's basically, I know you must have 10 million questions, but I'm asking you if you could keep them until the end, and I'll answer all at once, if not simultaneously. Now, I said earlier, one moment. Thank you.
Okay.
Oh, that feels better. Now, as I mentioned earlier, there are other forms of alternate dispute resolution. Although arbitration is the flavor of the month, so to speak, there are others which are different from the court system. And we are now, the point I should make is that arbitration is a method of settling commercial disputes. Why do I say commercial? It is because we cannot deal with not necessarily. Well, we could actually, yes, we could deal with domestic disputes if the two parties to the dispute, perhaps whether they are wife and husband or some other combination. But the point I was going to make was that we can only restrict our activities to commercial disputes as opposed to criminal activities. Criminals can't go to arbitration, in other words, no matter how much you would prefer to. So, my apologies. Now, but there are, as I said, many other forms of ADR, which is settling disputes, and all of them are based on the same principle, and that is of recognizing the facts, if not the details of their dispute, a willingness to settle and abide by the result of their process. In the event of the ADR process, because it is voluntary and consensual, fails to arrive at a settlement, it may be referred to the court for settlement. But that is only in extreme cases. So allow me, ladies and gentlemen, to deal with the first and probably the most widely used alternative, which is mediation. As with arbitration, mediation provides both parties with an opportunity to agree on a single mediator. Anybody can be appointed as a mediator, who will then proceed to call the parties together and I lost my train of thought for a moment. Because I was really thinking about the Dispute Resolution Foundation, which I'm sure many of the members here today are aware of, but the DRF has been the main body that has been dealing with mediations. And as I said before, there are rules of the game which apply to mediation as well as arbitration. And these basically are founded on the Supreme Court's civil procedure rule number 74. And if I could just read to you briefly what that says about mediation, what it is. It is a dispute resolving process in which a neutral third party, called a mediator, facilitates and coordinates negotiations by the parties in a dispute with a view to resolving or reducing the extent of the dispute. And Part 74 of the Civil Procedure Rules goes on to say tell us what the objectives of arbitration are. It improves the pace of litigation. And what does that mean? That means that the tremendous caseload presently in the court system in Jamaica, which is, as we all know, clogging up the system, can be, by order of the court, certain cases can be referred, instead of being heard by the court, referred to mediation in accordance with Rule 74. It promotes early and fair resolution of disputes. That speaks for itself, I think. It certainly reduces the cost of litigation to the parties. In other words, it's much cheaper and more, in most cases, more efficient than going to the court. It improves access to justice. In other words, justice denied, quoting the cliche, justice delayed, rather, is justice denied. And so on. So the mediator's role is to help monitor the communication between the parties. The monitor doesn't act as an advisor or a counselor or any advisory role of that kind. He or she has to make sure what is being said is clarified and understood by both parties. At the center of mediation is informed consent, so that when they come to the table with some understanding of how mediation works, and they are willing to cooperate and give it a try. So in other words, the will of the parties in mediation is just as important as the act of the mediators themselves. It is important for the parties to trust the integrity and impartiality of the mediator. He or she must ensure that the negotiation sessions are private and confidential, and there's no need for any minutes or notes to be kept, and because any notes made by the mediator are personal to them, unlike a judge in chambers, which is different, and may not be demanded to be produced in any further actions, again unlike a judge in the Supreme Court or any court. Neither can, in the case of failure to come to any settlement, the mediator be a witness in future arbitration or litigation. A very important point, which has lots of ramifications, which if we have time we can go into later. But the important thing is that the mediator cannot be, if the mediation fails, he cannot be called as a witness or even disclose any of the information he has received due to the total confidence of the parties. Well, so much for mediation. There's another method of settling disputes called conciliation. Although it's an accepted form of ADR, it's not really a system. It's not as far as I can see anyway. And it's not very popular here in Jamaica, but I mention it just to give you an idea of what alternatives consist of. What it does, it involves a more formal experience than mediation in calling for the parties to reconcile their entrenched positions in the dispute in order to arrive at an agreed settlement. The process, the main advantage of which is total privacy, is usually conducted by attorneys, resulting in a largely more expensive cost to the parties than other forms of ADR. Another form of ADR, since, as I said, there are more than one, is a system not too much used here, but it's used quite widely abroad. It's a system usually restricted to disputes of highly technical or scientific nature, where the core of a dispute is exclusively concerning a particular industrial or commercial process or system knowledge of which is not in the public domain. Such cases will involve the appointment of an expert or a specialist representing the arguments of a party with an agreement on a third and equally qualified person acting as an umpire, whose adjudication will be accepted as final by the parties. Going on to another form, used in the United States. I've never seen it used in Jamaica. But it's disputes where the core issue, that is the issue on which the whole dispute depends, is an interpretation of specific points of law. And it's used by the parties as a more economical method of assessing a party's chances of success or otherwise in a costly legal action. Here, an accepted legal authority, usually a retired judge, will hear arguments of the attorneys of both sides and give his or her opinion of who will succeed or fail should the issue ultimately go to court. Then, just to give one more of two last examples, Med Arb. It's a hybrid form of resolving or reducing the number of individual items in a dispute. Now, normally, an arbitrator is strictly bound, in order to be impartial, not to use his or her technical or legal knowledge to influence the progress of evidence that's being presented. But in this form of settlement, they are. with the prior consent of both parties to the dispute, allowed to intervene to influence the parties to come to some kind of resolution. I almost said revolution, forgive me. Or to break a deadlock preventing progress. In my experience, especially in the case of non-complex issue, it's a handy and judicious way to convince the parties that hardly ever is a party in a dispute 100% right and the other party 100% wrong. Okay, that leads me to one of my favorite forms of, especially in the construction industry, forms of dispute resolution, which is called adjudication. Now, earlier today we heard under contract administration, we heard, and I must compliment Mr. Donald Moore on his brilliant presentation, which included reference to FIDIC. I'm not sure if everybody understands what FIDIC means. It's not a bad word, but it is an acronym standing for an International Civil Engineering Contract, which we do use in Jamaica, and the NHT seems to have a predilection for it. Let me say, in the past, parties to commercial disputes in the construction industry, because of the standard arbitration clause in most local contracts, and here I say local contracts because away from FIDIC and certain government contracts, all of our private commercial contracts usually are based on the standard CIC, Construction Industry Council standard form of contract. But in those contracts, the contractor has to wait until completion of the work for those disputes to be dealt with. Now, I maintain that in an era of high interest rates and lengthy contract periods, this proves onerous to both employers, and contractors. Then the industry realized that a new and relevant system was needed. This was found some years ago, by the way, in the UK as a formalized version of the well-established FIDIC standard dispute management system of what Mr. Moore referred to as DRBs. DRB stands for Dispute Review Boards, or you can have a DAB, which is a Dispute Adjudication Board, which is usually used for civil engineering contracts as opposed to building. So what emerged was that adjudication, and where both parties to an agreement, preferably prior to the beginning of a contract, but it could be at any time thereafter, agreed to an individual who from the beginning has the contractual power to receive, hear, and settle disputes as and when they arise during the course of the project. She or he will then issue a decision to which both parties must conform until the end of construction. Then, if one party is still aggrieved, it may be arbitrated. What has been found is that once experience, but mainly in the UK, not so much in Jamaica, has proved that settling individual issues as and when they occur, effectively nipping them in the bud, as you might say, they then cease to become exacerbated and blossom into full-scale disputes. A strict requirement now, not a choice, but a requirement for adjudication is now contained in most UK and international construction contracts. For example, World Bank, Inter-American Development Bank, Caribbean Development Bank. And, Mr. President and members, ladies and gentlemen, I strongly suggest that we in the industry seriously consider proposing that its use is mandatory in Jamaica. The savings in time, energy, and cost will be enormous. That is all I wish to say at the moment about adjudication. Commercial break. Well, ladies and gentlemen, all that we've discussed so far, and probably most of the day, has been a look at some of the various methods of settling disputes in the industry after they have become disputes. And as I mentioned at the beginning of my talk, I would like to share with you now a personal view on this matter. And that is that my observation of conflict in our industry over the many years I've been in practice in Jamaica has been that avoidance is by far preferable to conflict or dispute settlement. Or, if you'll allow me to quote an allegorical story of this doctor in rural India who for years was trying to find a cheap, acceptable method of birth control. And when his female patients came to seek his advice, he would say, "It was very simple, my dear. All you do is drink half a glass of warm water." And they would say, "Oh, you mean, doctor, before or after?" And he would reply, no, instead. So that illustrates what I meant by prevention is far better than cure. But put into realistic terms, roughly 80% of the arbitration cases I've dealt with concern disputes of, and I'm sure these expressions are familiar to most practitioners in this room, extensions of time, variations, measurements and quantities, imperfect relationships between the various members of the so-called team. That's what Ray McIntyre was talking about quite rightly earlier. Late on non-payments and so on, all of which I'm sure are familiar to those here today, and most of which could have been avoided if the projects were fully designed, costed, time-planned and correctly financed prior to commencement of the project.
Hear, hear.
But ladies and gentlemen, supposing there was a system that went a long way in avoiding most, if not all, of the disputes that presently plague us in our industry. Wouldn't that be wonderful? Well, I'm happy to report there is. There is such a system. It's a system that was developed again in the UK and has spread to US and to Europe, and it is called Building Information Modeling, and everybody refers to it as BIM for short, Building Information Modeling. Okay, what it is, basically it is a virtual, digitally constructed representational model of the intended structure incorporating all aspects of the design, management, life cycle costings, all types of other costs and inputs constructed within a framework of all participants in the construction process, such as architect, engineers, mechanical, electrical, QSs, IT experts, interior designers, anybody else who has an input into the creation and success of a structure. It needn't necessarily be a building. It could be a bridge or a highway or anything. But the principle is that the BIM may sound like a revolutionary idea, but it has been successfully used in the UK for several years and demands initial involvement and group discipline. An important point, that group discipline, which I suppose also includes the question of group respect for one another, architect, engineer, QS, so on, of all participants. What it is basically, it is a computer program that has to be, or the inputs of which will three-dimensionally show all components of the building, including architecture, structure, engineering, and interiors, social services, and so on, all separately identified, which can be shown in 3D and analyzed on their own, on a computer screen obviously, or collectively. And at this virtual stage, it will show up many of the coordination problems usually encountered and can be correctly can be corrected digitally, pre-contract, instead of, as in the past, on the site, creating variations and confusion. And it has been very successful in its use, to such an extent that as long ago as May 2011 in the UK, the UK government stipulated that by 2016, which is next year almost, really, all centrally procured public projects should be planned using BIM. The European Union, in a public pronouncement directive, followed suit, and in March of this year, 2015, recommended its use. I could go on about this new method of BIM. It's a bit complicated. It will take a lot of study, it will take a lot of research, but in the long run, and hopefully with the impetus of the IMJ, we can see its development in Jamaica. Well, ladies and gentlemen, that probably sums up more or less what I'd intended to communicate to you this evening.
Thank you very much, Patrick. Can I ask you to give Mr. Patrick Gordon, our MC for today, a rousing round of applause, please? Well done, sir. Just to say that we have been given a recommendation for those of you who were here today because you wanted to qualify for some additional hours of continuing professional development. The recommendation is that we use 5.5 hours, and we're going to go with that 5.5 hours towards your professional development credentializing. So please, we will be communicating that in our certificate going forward. Okay, Mr. Stoppy, we don't think that this will require any arbitration, adjudication, or anything, or BIM, right, or mediation. So we're going to ask you to draw the winner of the ticket for two to the Carib Cinema. So you can just take out your numbers just to see if somehow it corresponds with what is going to be drawn. I'll read the number. It's 34. Number 34. Not here. You're very quick on the mark with that. You sure? Well, okay. The only adjudication or arbitration or, what's the third one again? Mediation that might arise is if there's any conflict or dispute about who you're taking to the cinema with you. So please come forward, sir, if you have a 34. You have 34, sir? Please come forward, sir. Please come forward. Thank you so much, Mr. Stoppy, for the first act of conflict-free resolution. Well, it wasn't a resolution. There's no conflict. There's no resolution. Congrats, sir. Glad to see you. 34. Gordon. Okay. Gordon. Yeah. It's Gordon. Congratulations. The heart NTA 1 All right. Just make sure the number. I've been asked to make sure the number is 34. It is 34.
Congrats.
No, I thought I was just in between. The last one, I think, which is one of some note and worthy of serious consideration, is a manicure, pedicure, body cure. No, it's called a full body massage, actually. So it's a mani-pedi facial. It's a mani-pedi facial full body massage. No, man, I'm trouble free on this one. So please, could I ask Mr. Stoppy again to dip in and see if we can allow someone to benefit from these four rather low stress or leisurely activities that I'm sure you want to be a part of.
What's that?
It begins with a 1. That hiss was very loud, brethren. It continues with a 1.
One.
Those hisses were very, very, very loud. And it ends with a 3.
1-1.
Scott, it's 113. Do we have a winner? 113?
1-1-3.
The gentleman is very cool, very calm. Please come forward, sir. So that's the winner for our last prize this afternoon. And I just want to say that this is compliments of Jane Care Skin Farm. So you know that this is a very high quality spa. So it's really, I am sure that you will be enjoying this, sir. The matter of who we will give it to.
Yes.
May I sit down before? Because you're accusing me of.
Yes, to go resolve the dispute.
Before. Congrats, my brother. Look at it. All right.
Thank you very much.
Okay, ladies and gentlemen, it just left for me to just say a very hearty thank you and safe travels. And really, today has been a very great day. I think we have been, fed and we have been watered and we have been nourished and nurtured. Want to just say a big thank you for all those who especially came from out of town, and those who have been here for the first time. Next year we are going to be back here again. It's an annual seminar. It is the IMH's annual event, and we look forward to seeing you here next year again. All the best. Godspeed. Thank you again.